Good afternoon. I'd like to call the Subcommittee on Seismic Mitigation to order with a roll call so we can establish a quorum.
Assemblymember Buchanan.
Here.
Kathleen Moore.
Present.
Scott Harvey.
Present.
We have a quorum.
All accounted for. This is our fourth meeting, and it is one that culminates in the work not only of the committee, but direction and guidance provided by the Allocation Board at its last meeting. We've taken lots of testimony, heard lots of reasons to improve on the program we had, and before us are regulations which do that. It alters the way in which we look at buildings. Rather than looking at a handful, we're going to look at all of the Type 2 buildings. And rather than having a shake zone standard, we're going to rely on a structural engineer's report that is conformed in and validated by DSA, and only if there is a presence of faulting, liquefaction, or landslide hazards will that be documented by a geological hazards report prepared by an engineering geologist. We'll get into the regulations themselves very quickly, but I kind of wanted to set the framework. I want to thank the committee members for their diligence and work on this very important issue. And unless either one of you have a comment, we're going to talk about an amended report. I want to make sure members of the audience have the most current version of the regulations. We had to delete one sentence. At least staff is recommending the deletion of one sentence. It gets to concerns that we feared could be raised by the Office of Administrating Hearings. Remember, they've got to approve these regulations, and we'll get to that, I assume, when staff makes their report. So again, if you have something you would like to add, Assemblymember Buchanan or Ms. Moore, now would be the time, and otherwise we'll hear from staff.
Perfect. I think you covered it.
David, are you taking lead on this?
Yes, sir. Good afternoon, Mr. Harvey, members of the Seismic Subcommittee. So in accordance with the May 25th State Allocation Board meeting, we have looked at the defining regulations governing the Seismic Mitigation Program and endeavored to make appropriate changes to those regulations. I'd like to direct your attention, first of all, to page 2 of the agenda that you have in front of you. There were no changes to this page, so this, if you have the old one, you can still follow along, and I'll highlight for you the changes. So in the definitions, this is a section that deals with defining formally the most vulnerable Category 2 buildings. You'll notice we're striking out most vulnerable and some language related to DSA, and the reason for that is formerly we had only the quote-unquote most vulnerable, the buildings that were at more risk within the Category 2 buildings. There are a total of 14 buildings in that Category 2, and formerly we only had 8 of them in the regulations. So you'll notice we've added an additional 6 building types, so this now includes all Category 2. So that's the reason, the primary reason for the most vulnerable striking. You'll also notice the main change here with the strikeout is that the short period spectral acceleration language, etc., is all deleted, and that's as a result, again, of the board direction that we not use the spectral acceleration as one of the defining most vulnerable criteria. So then if I can direct your attention to section 1859.82, little a1, you'll notice that the language down towards the bottom of that A1 paragraph is struck out. It isn't all completely gone. It's moved over into a new big subsection C. And this language was originally put here when the program was first set up. It was subsumed into the larger facility hardship, and for the sake of clarity, for the sake of the direction we're going, to provide real clear direction on the seismic mitigation program, we felt we should create a new section and just deal specifically with the seismic mitigation program and the criteria for that.
David, if I may, for
Yes, sir.
clarity, ask you a question, because I think I know what you've done, and I want to make sure it's covered, because while you've struck the term most vulnerable, and you explained why in that very first paragraph under 185.9.2, because we now have the whole of the Category 2. Throughout the rest of this document, that phrase is used.
Yes.
It is used in that facility hardship that you just referred to. It's the seismic mitigation of the most vulnerable Category 2. So I'm assuming we don't have to define it per se, because now all of those building types are considered most vulnerable.
Yes.
Is that the reason we
and you'll
don't
notice,
need to define it somewhere?
That's correct. And you'll notice that whenever we uppercase something, that means it's a definition in our subgroup 5.5 regulations for the school facility. You'll see most vulnerable now when it's mentioned in here, it's lowercase now. Okay, so it's
Did
not.
everyone know that? How many of you,
part of
can you
that.
raise your hands if you knew that uppercase meant it was a definition, lowercase meant it's just the term? All right. I see 3 hands. Very impressive. 4, 5. Oh my goodness, the count goes up. Okay.
I think Bruce Hancock back there knows about that.
Ms. Buchanan, you have a follow-up?
So, yeah, I do, because I had the exact same question, whether it's capitalized where it's a definition or lowercase where it's descriptive. Isn't there still implications in there that some are more vulnerable than others? I mean, how are you intending it to be used with the lowercase descriptive?
Well, I think if you take it in the sum total, if I can direct your attention to page 3 in the large C section, most vulnerable, Category 2 is going to be one of the criteria. You have to be Category 2. Mm-hmm. You have to have DSA concurrence of a local structural engineer report. The building has to be designed for occupancy by students and staff. And if there's a geohazards condition such as landslide, liquefaction, those things listed in the regulation, then that has to also be documented by a geohazards report and have concurrence by the California Geological Survey. Those criteria taken in the sum total after approval by those 2 agencies, if those things are an issue, well, always in DSA's case, would constitute a most vulnerable building. In that context, does that help?
The totality of the regulation to say it's the Category 2 type buildings, and then this gauntlet of 1 through 4 under subsection C. That gives you the definition of most vulnerable.
But we're not using it as a definition. I mean, I'm just wondering
Correct.
if somewhere there should be a descriptive in terms of, we were trying to get away. I mean, I don't know if there's anything open to discussion later on in terms of, we're saying most vulnerable Category 2, but if we don't somewhere say what we mean by that, because when we dealt with it at the board meeting, we talked about buildings in imminent danger of collapse. And so we're not defining most vulnerable Category 2. We're talking about Category 2 buildings that are in danger of collapse. So I just want to be sure there's common understanding in terms of what we mean there, because I'm not sure there is, but
Well, you and I, Ray,
Right,
thought
yeah,
the
same.
same way, and I
Yeah.
think it's worth discussing. We'll get to that perhaps after you go through your report, and since we're adding things to talk
Right.
about, the other one I wanted to was, this term, I've heard it, imminent threat of collapse.
Right.
We don't use that here. It
Right.
is potential for catastrophic collapse in a seismic event. And I wanted to make sure I understood if that phrase
Right.
was the proper phrase, because we've heard, I don't know how many times, you've got to have some objective
Right.
standards. You
Right.
can't just throw it open. And
I'm actually comfortable with that. I just want to be sure that most vulnerable ties to that, and we're not in danger of interpreting the 2 of them differently.
fair enough. In a moment, Mr. Smoot, in a moment. David, I'm sorry we cut you off. Why don't you go through your staff report? We'll have member questions, and then we will go to members of the audience.
Okay, so if I can then direct you to, unless there are any questions on page 2, maybe I should ask, are there any further questions before I move on to page 3?
Seeing none, we'll go to page 3.
So on page 3, I briefly went through real quickly, but I'll highlight for you, dissect this a little bit more for you, if I can beg your indulgence for a minute. So in big C now, that's added all the underline here and bolded for you. It starts off with the total available seismic mitigation related and ancillary costs for most vulnerable Category 2 buildings. We talked about the connotation of the lowercase most vulnerable is $199.5 million for projects that meet all the following requirements. That language was essentially parsed out from page 2, the struck out area, you'll notice. And if you look at C1, that also was parsed out, taken out from, and recategorized in here in this new C. It was just language that was carried forward. Any question about C1, that date, May 20, 2006, is just the effective date of the language for the Prop 1D bond bill. That's when it was approved. And, you know, that was for the bond that was approved in November of 2006. But that was the effective date of the enabling legislation. So, and again, that was just language we carried over from the former strikeout. And then, so if you get into C, embedded in C, just the lead in is it has to be a Category 2 building, criteria number 1. Then if you get to C2, the project is funded and shall be the minimum work necessary to obtain DSA approval. Where did that come from? It's over on the other page, struck out. It's just recalibrated here. C3, the building is designed for occupancy by students and staff. That's a criteria now, and that's a carryover from the old program, the other Seismic Mitigation Program. Now, C4, and this is the change, hopefully, that everybody has. The language has changed a little bit from what was posted on the web, and I can just read it into the record if that will help. It's been streamlined a little bit, but it says the...
Please do.
Okay, so the new language that has just been passed out is the DSA concurs with a report by a structural engineer which identifies structural deficiencies that result in a high potential for catastrophic collapse in a seismic event. And there was another sentence in here, but that's now gone. And this last sentence then that I'll read was formally here, and it's still here. The presence of faulting, liquefaction, or landslide hazards must be documented by a geologic hazards report prepared by an engineering geologist in accordance with the California Building Code section 1803 big A, and has to have with the concurrence of the California Geological Survey. So if a site, I'm sorry.
Go ahead. I didn't mean to cut you off. I'm very.
So I just want to make sure that it's clear here. A geohazards report would have to document if you have one of these situations. Only in those situations where there's a liquefaction, a landslide, faulting issues. Those issues would need to be documented in a geohazards report and have concurrence by the California Geological Survey statewide office, in order for that to be, you know, a concurrence as a part of this. So it's like a fourth criteria in those kinds of situations where there's faulting, landslide, liquefaction.
I agree with the intent in that, but could you elaborate for me? Because, you know, it makes sense to me if I'm saying the hazard recurs from the fact that based on the type of soil, and, you know, if you have an earthquake of 6.0, we may have liquefaction, which will cause the building to collapse. So certainly if that's what you're basing your justification on, you should have to have the soils engineers or others that document that in fact is true. Is there a possibility that situation will not show up on a map? I mean, some of the testimony we heard over time was that these maps continue to be upgraded and improved and based on technology and knowledge and everything.
I don't feel qualified to answer that. Perhaps maybe we have a representative from the California Geological Survey here, Jennifer Thornton.
Thank you, Jennifer, for being here.
Maybe
will
could
come
speak to
forward
that better than I could.
State your name for the record.
Thank you. I'm Jennifer Thornburg with the California Geological Survey. And the answer to that question is where the state has done the mapping, that is fairly well defined, but there's a large portion of the state where we've not mapped yet. For instance, all of Solano County, Contra Costa County, we have not mapped yet.
So I was just relating that to the situation with the gym at Santa Ramon High. If you hadn't mapped that and that was the reason we granted it, then would you not grant it because there's no mapping that's been done, even though you had a geological, like even though you had the engineers and the drillings and everything else? I mean, how would you deal with that? How would you deal with the request from Contra Costa Sonoma, one of the counties where the mapping's not done?
If I can, it would also require a site-specific analysis.
Right.
The map zone areas just show where there could be a hazard.
Right.
That does not mean that there's such a large hazard that it would end
Right.
up in collapsing the structure.
Right, and that's why we actually were changing to these requirements, because we realized that it was more than just being on a broad map, but we had to deal with it site-specific. But my question to staff then is, you want it verified by a map, but if we don't have a map, what do we do in terms of qualifying a school?
Yeah,
I think we have to defer to DSA to answer some of that question.
Jennifer, if you would please stay here on the off chance that there will be other follow-up questions, I would appreciate it.
Good afternoon. Chip Smith, acting state architect. I believe the school project in question, it wouldn't necessarily have to be in a mapped zone. It simply has to have a site-specific study that's concurred with by the CGS. And if the site-specific study identifies and quantifies the hazard, whether it's faulting, liquefaction, or a landslide hazard, and it was concurred with by the CGS, then that's then they've met that criteria.
The language says, and with the concurrence of the California Geological Survey. Mm-hmm. If we haven't done a survey, and you have the soils engineers and others that say this is a problem, are we talking about the agency? Are we talking about the survey? What happens to that project?
the agency.
Jennifer, again, that would be with the agency's concurrence. We would review that report and ensure that it was done correctly.
Okay.
Can I ask the question a little differently? Are we saying that you must have a geological hazard report concerning the presence of faulting, liquefaction, or landslide hazards in order to qualify?
Yes.
And so if you had an engineer's report, the first sentence is, a structural engineer which identifies structural deficiencies that would result in a high potential for catastrophic collapse. The only way that you can have catastrophic collapse is if there's one of those three issues occurring?
No. Ground shaking is the dominant hazard in the state. And for ground shaking, we have standards to work from. That's the building codes based on ground shaking. So for the hazard of ground shaking, we would not require the geologic hazards report. Okay. For the other hazards, we would, because...
Do you think it would be better to have the language say, if there are faulting, liquefaction, or landslide hazards, they must be documented by a geological hazard report? And that way, it's clear that you could be meeting the first sentence with a ground shaking problem and not have liquefaction, a fault, or another hazard. That correct? That you wouldn't need. You only need the survey if you have those issues that are evidencing your request.
Correct.
That's a very good clarifying suggestion. I will rely on staff to add that.
Oh, someone else?
Well, I had suggested to me that additional factors, including but not limited to faulting, liquefaction, or landslide hazards may be considered but must be documented by a geologic hazards report. Same idea,
different angle, same.
But you're adding things that have to have the geological hazards report by saying additional factors. So you're adding to the number of things that have to have the report, and that
Well,
May make sense, it may not.
if it's not the shaking, but you're saying the problem is liquefaction, then clearly you should have documentation that supports the fact that you could have liquefaction. That's what's causing the problem.
Has staff seen this? If you come get this, I kind of like this. Are you more comfortable with this? Or do you like the if?
And I'm okay with Ms. Moore's suggestion as well. I mean, and I'm okay with you could potentially come back with something, when they come to the full board.
Yeah, I think it just needs to be clear because the question came from a school district, do I have to have those?
Right.
And I said, I didn't believe that was our intent, but that's part of why we were meeting today. So I think it should be clear for school districts.
Well, we'll ask staff then to think in terms of what Assemblymember Buchanan has offered and what Member Moore has offered, and before we see it, or as we see it at the board, that change will be included. Any other questions of the Geological Survey or DSA at this point? Let me ask one. This is a really nitpicky, but I'm looking at the very first sentence under large sub C, and technically we don't have 199.5 million. We've got less than that.
194.8 million to be precise right now.
Let me also add, for perhaps discussion, we've got 21 projects in the pipeline based on the old standards.
No, we don't.
I thought we did.
We have 21 that have said they want to look further into the safety of their schools, but they actually haven't.
Okay. Is that what it is? It's not, they haven't yet.
21 have been pre-approved by the former Seismic Mitigation Program standards, but they still need to have plans drafted up through DSA approved and an actual Seismic Mitigation Program facility hardship request filed, and we don't have any of those
But
yet.
those 21,
They weren't pre-approved.
No, they're not.
They were surveyed.
It was a pre-screening
They were-
of the criteria.
And my understanding is there are 21 that are potentially eligible. They still have to do their own engineering reports.
Yes.
To determine that, yes, there is a problem.
That is correct.
So.
Thank you for that clarification. I knew there was another number out there. But the point is, I'd feel more comfortable if you accurately reflect what's left. Small point.
I'm wondering, though, if we should, because this regulation
Deals with the total amount.
deals
Does
with
it?
the total amount, the whole
I
regulation.
had the same thought you did, and then came to Kathleen's conclusion. Yeah.
Okay. Once again, I'm love to be corrected, as Mr. Duffy knows. We'll leave it at 199.5.
And I should probably also add that, let's not forget, there was a fourth seismic mitigation project approved for conceptual. It wasn't an unfunded approval, but it's, that's West Contra, Costa County. So we really have about 180 million if you throw that into the mix too, but that's not an actual dollar amount yet because it's only a conceptual approval. So.
Okay.
Okay.
Any other questions on this? And let me, if I may, find out, Dave, why don't you go through the rest of DE, and then we will take public testimony.
Okay, so then moving on, the regulations then go on after C1234. It lists that the structural engineer's report shall conform to guidelines provided by DSA for preparation and submittal of such reports. And then if the DSA determines that the information contained in the reports is inaccurate, then they shall reject the submitted reports. So the guidelines will be provided by DSA on that.
And before I go too far, I want to make sure for the record we have the staff recommendation for why that one sentence in subparagraph C was deleted. I think the issue was making certain that we didn't create a potential obstacle at the Office of Administrative Hearings that has to approve all regulations, and that sentence could have given them angst, as I understand. It doesn't fatally change the dynamics of this as a public policy statement, and we still have the engineer's report conforming to guidelines, which DSA will develop and publish. So we've covered off the criteria, but it's that we're not including a national standard reference in the regulation. Is that why we took that sentence out?
That's essentially it, Mr. Harvey.
Thank you. DE, that's set. Anything more to say about the rest of this?
Well, on D, if I could just preface, the purpose of that is just to deal with the funding order that future seismic mitigation projects will be funded in order of receipt until the $194.8 million is approved by the board, either through an unapproved apportionment, unfunded apportionment, or an actual funding apportionment. And then E deals with when we get to let's say we get to the last dribble of money in the program and the last project, and let's say there's less money in that amount left in authority for the seismic mitigation program to fund the last request, the latest one that's come in. This regulation E provides clarity that the district will have the choice of accepting a reduced apportionment or a haircut, if I can use that terminology, or they can waive off and say, no, I don't want to accept that. I'll wait for something else in the future possibly. So that's what that deals with. And then the last paragraph, the second paragraph under big section E, just deals with it. We will return any applications after all the money is subscribed for the program. Any applications we have in-house or that come in will just be returned.
Thank you. And sub E is something we have done in other programs. I know Mr. Smoot took a haircut recently, took less money, then defer to the project next in line. So this is not new, is all I'm suggesting. This language is not new.
Yeah, that's it.
Okay. And if I could add one other thing, I don't believe we have this out here, but we have just a little technical minor change, if I can, again, ask for your patience on this. In the 50-04 cover sheet, directions to our application for funding in the program, these are incorporated by reference, so these also carry the weight of regulations also, if you're not aware of that. But on page 2 of 9, up at the top of the page, we have a section here, again, that deals with the most vulnerable category 2, and it's all uppercase because that was formerly in the regulations, a defined definition. So we are going to need to make a conforming change there and make the most vulnerable lowercase. So we'll do that also just to make sure everything coincides and is in a correctly worded. So I just want to add that here. Sorry about that last minute change.
I have a couple of comments on that. So I think it's a continuation of what we talked about earlier, but haven't we defined most vulnerable category 2 to be category 2 with a structural engineer report? So can't we just move that definition to definitions? I mean, previously we defined most vulnerable category 2 to be ground shaking and
certain buildings, yeah.
And certain buildings. So now we have most vulnerable category 2 buildings that carry a structural engineer report. That's the most vulnerable category 2 building that we're defining. Why wouldn't we define that?
If I could just clarify, Ms. Moore, so basically move section C under the definitions.
Or you could reference section C because that's what we're defining now.
Right.
And that's what we're regulatorily, that's our regulatory action, isn't it?
Yeah. And I said, aside from formatting, I don't see an immediate concern, but it's something we can definitely take
I think all three of us expressed an interest, a little discomfort by not having it defined and striking what had been defined. This, I think,
or even if you, refer to it.
We can take a look at that.
And staff will bring back that
and then
to the board.
I do have just a little exploration on E for the return of applications. What other programs do we return applications in when we reach the total amount?
Career Tech, COS, and I think there's probably other programs here off the top of my head, but Career Tech, COS, there's a third one, Joint Use. So we tried to we went into those sections and looked at how we deal with those kinds of situations when money is all subscribed in those programs, and
then
so we tried to follow that.
We don't do it for modernization, new construction, high performance.
That's correct.
So we're inconsistent on that issue, which is a big issue across our. I didn't realize that. I was concerned of returning of applications. That's a very big issue when someone has submitted an application, and we're a little schizophrenic in it because historically we've created a line I'm aware of in new construction and modernization, and also it appears historically in this last bond measure we've ceased a line for things like career technical education and critically overcrowded schools. Have we sent back critically overcrowded school applications?
Not to my knowledge. Do you?
Have we
the
reached
initial
that
preliminary apportionment, when we talked about the initial preliminary apportionment versus funding, they got the reservation of funds. I believe the first round we were oversubscribed, second round we weren't, but if we didn't have enough under the preliminary apportionment stage, we would send them back. And just if I could just further comment on this section, this is also consistent with prior board discussions about the creation of an unfunded list. Now, whether the committee or the board wants to have the discussion, and I don't know if this is where you're heading, Ms. Moore.
It is.
Then it's up to the committee and the board to have that discussion. But it's consistent with prior discussions that the board had in dealing with seismic, the 199.5.
Well, we didn't have it in the previous seismic regulation, correct?
Correct.
So it is a change that we're saying now we will return applications. So it is a change from our previous, and we still had 199, so there's no difference there. And I think it's part of a larger discussion about whether we have truly an unfunded list, not the one that we currently operate because of cash flow, but a true unfunded list. And I, for one, would want to consider that at the time that it happens, as opposed to lock in, we're just going to return apps, which to me is a much more concrete action now that we will not have an unfunded list, because that makes that determination now. But I'm open to what other board members think about that as well.
Before we comment, Lisa, did you want to add something?
I know this was actually a discussion item that the board did grapple with back in August of '09 as far as whether or not you want to go beyond the limits. And at that time, that board did recommend not to go beyond the 199.5 as subscribed at that point in time. So obviously it's up to this committee to just...
It's not reflected in regulation.
No, it's not reflected in regulation.
So
This codifies that preference.
Right, exactly.
I, for one, am comfortable with it by virtue of what direction we had received before. That doesn't mean a new board can't undirect, but based on that, and I recall the comments pro and con, I am comfortable leaving it in at this point.
I don't have a strong opinion, because it really gets to the question where you have more history than I do of how do you transition from one bond program to another, and that probably is going to involve a much longer conversation, because once we've spent all the $200 million, clearly the seismic money is gone, and to hold applications for a seismic program that you may have in the next bond or you may not. I mean, I'm not sure it makes sense, except that I understand Ms. Moore's concern there.
A couple of thoughts. By recommending that we cut it off today, that makes that decision now. And I believe that the board, on a more general basis, perhaps for the programs of new construction and modernization, indicated we will make that decision at the time that the action happens. That when we truly run out of funds, let's decide what we're going to do with an unfunded list. So for me, that creates an option for the board to consider it at the time that the action is needed, as opposed to anticipate the action. And I'm more comfortable there. Mr. Harvey and I might disagree on that, but I'm more comfortable there. And then secondly, we've had an unfunded list historically in this program to demonstrate need. And that has been an important component, I think, in terms of demonstrating to the people that we ask to approve bonds statewide that indeed we have needs and we're trying to meet them. It has a double-edged sword of you have needs. So, that you have a problem that you're going to have to deal with. But it's been, I know in many of the previous bond measures, it's been a very valuable tool to demonstrate need, and I don't think it's one we want to, I, for one, wouldn't want to act on right now. But there may, as we transition down in this bond measure, I think the board should look at this across all programs.
See, for me, the AB 300 report, which is evolving and changing, sets out a very graphic statement of need, rather than a handful of applications that may or may not be pending at OPSC. To me, that says statewide, here is the need. But this is a subject that obviously we can certainly discuss at the full board. Again, did you wish to add something to this relevant issue?
Just, yeah, and just,
please.
Mr. Chair, the biggest distinction that I know was made previously was the fact that unlike new construction modernization, we're talking about health and safety issues with the seismic program, and this was the first program that was created under Proposition 1D for these types of projects that demonstrated this type of issue, and there was some sensitivity with the liability, potential liability that was discussed previously. So just wanted to clarify that.
Why don't we highlight this in the staff report that goes to the board, that there were questions raised on the merits of this, and you can talk in terms of the August 09 action and the justifications thereof, and make some of the other counter arguments that Ms. Moore has made about holding off and the advantages of doing that closer to the time at which the money's actually gone. It'll be discussed at the full board, I am sure. Do either one of you have any other questions before we turn to public comment?
I do have one other question, and it's on the paragraph immediately following the C1234, where we say that the structural engineer's report shall conform to the guidelines provided by DSA for preparation and submittal of such reports. If DSA determines the information contained in the report is inaccurate or incomplete, it shall reject the submitted report. If we need additional information, if we get the information from the school district and we say, well, this seems reasonable, but I need more justification, whatever, is it standard practice to reject a report, or do we clearly, if the information is found inaccurate and it doesn't qualify, I would think you would reject. But if there's a situation where we need additional information, is it our practice to reject or to request additional information from the district?
It would be to request additional information.
So could we then also do something with this wording here, so we're not, if all a district needs to do is provide additional information, so we're not completely rejecting their application?
There has to be some reference to what this due diligence is back and forth, and at some point, if they can't do what you ask, you're going to have to reject it. But I think what Buchanan is looking for is a statement that reflects what you actually do in practice, which is request, and hopefully they then complete the application.
Is it more, Chip, that you have two choices when these come forward? Not choices, but two responsibilities, either to concur or to not concur.
Yes.
So is there some type of language? I mean, we have the if DSA concurs with the report in the for language. This seems to be handling the case that you don't concur, or it's either you think the report is inaccurate where it's not complete, you really don't concur with their findings, I'm assuming. Or is it more, or is there one that you might not concur with their findings, but in this case, it's only, you don't think it's complete?
I think, well, first of all, we could handle minor concerns through our procedure, our template that we're using now. I don't know what the template actually says in this regard, but in practice, when we find minor errors or missing information that we feel, if they can provide it, may render the report acceptable for concurrence, we would contact the client and do so. In the case that we identified significant omissions or errors, we would still probably contact the client to confirm that that's the case, but then we would probably, based on their reaction, reject the report. It is possible they may be able to respond so that we could continue the process and complete and concur with the report. It probably can't cook up language right on the spot here for this, but
do you think you need this language?
We don't.
Or your responsibility is to concur or not, and if someone gives you something incomplete, that will be a possibility for inconcurrence, because unless they complete it and then you agree with it, or someone might give a report and your structural people say, we don't agree with these findings and we don't think that this, is an imminent danger, or whatever our language is here.
So let me try and probe a little bit farther. I mean, you're either, one, not going to concur with the findings and recommendation, right? And in which case you reject it. Under normal circumstances, what you're telling me, if a report, if the request is incomplete, you send notice back to the district so the district can fill in the missing information or provide you with additional information. If you have a situation where, based on the district's report, it looks like it might qualify, but they can't provide you with the engineering reports you need to substantiate the report, you're obviously going to reject it. So is it where they can't provide additional information? Is that what you're trying to say here? Or just when it's missing information? Because if I read this literally, it's saying that if I submit an application that's incomplete, you're going to reject it. I assume I'd always have the option of resubmitting it. But what you're telling me in practice is, if it's incomplete, you work with me to get it complete. But if they can't provide the supporting documentation, then I would think that would be a different situation.
Right. If the submitted report was egregiously incomplete, we would reject the report. If it was missing some information, but not significantly incomplete, we would contact them and request clarification. So I think it depends on the degree of error or incompleteness.
Well, again,
I wonder. Piggyback then on what Ms. Morris says, because somehow I think the language should reflect what we actually do in practice.
Either that, or let's talk about whether we need it. Because if we're really only concurring or not concurring, and you have that as your directive in this regulation, maybe that sentence isn't necessary. And Chip, you indicated you didn't think you needed it. And if that's the case, I think here would be more comfortable, rather than trying to find a way of defining the practice, particularly about incompleteness. I think inaccuracy we can kind of get. But at this point, why don't we drop it? And if there's a compelling reason that you think of between now and the board meeting to have something like this in here, you can bring it to the board. But at this point, let's drop that sentence.
Well, this sentence, but we have two different things. This sentence talks about conforms to the guidelines by DSA for preparation and submittal. So that's talking about having what you're submitting is complete. Then separately, you've got to concur with the evaluation, right? They're two different.
And that goes back to item 4 up above, right? DSA
C4?
Yeah.
Mm-hmm.
C4.
mean, I think one's referring to whether or not the information was filled out correctly. The other is concurring with the findings in the report.
She's drawing a very interesting line, which is it filled out properly? And you look at that and make a determination, and then you concur or not concur. So
well, and it says for preparation and submittal. It's not talking about concurring with findings. I don't, whether we leave it in or not, I just want to, I mean, my only concern is it follows what we're doing in practice.
Well, again, why don't we leave it off?
Okay.
And then if staff feels that there needs to be that light shown on the preparation and submittal as a separate activity from the act of concurring, they'll bring us something which reflects practice. And if you think there's a need between now and the board meeting.
I just wanted to conform with what we do in practice.
Okay.
If I may, just following up on that, because I think it will be very important for school districts to know, are you in the process, Chip and Masha, of developing the guidelines, or what do you see for that?
We would actually be modifying the current procedure, for DSA procedure 0803, to incorporate these changes. The procedure is currently based on the current regulations. And so with the new regulations, we would simply modify the procedure accordingly. And then the template that has been used for the projects to date, it would also be modified to address the change in the criteria.
And then, so districts would know that that's the guidelines, this is the template that their structural engineer must use in order to submit that report to DSA, and that can happen. Is that happen in your regulatory structure, or is that just by policy?
Policy.
Policy. Okay.
Yeah, not regulatory.
And that will be soon after we complete this, so people know what the lay of the land is.
The plan would be to have the procedure and template revised, vetted, and ready to publish when the regs are effective.
Okay.
Please, Masha.
May I add, Masha Lutzuk with the Division of State Architect, just to let you know that we do have several different processes for vetting our procedural and policy documents. So even though they're not regulatory, we do have a process for seeking input before they become official.
Can you describe that very briefly? What does that entail?
We do focus groups. Like for this one, we would probably seek input from the engineering firms that have been using the template, for example, the two that were contracted. Because if the template was to become used by a greater group, it has to be usable. So if they've noted any areas where statements could be clarified, we would seek their input. We would also then probably seek assistance from if there are any applicable committees on our DSA advisory board, we would do that, and then we do a electronic sharing of our documents also through the lists that we have available for vetting before they become
Thank you for that clarification. There may be other committee questions, but for now we will turn to public comment. If you'd simply come to the dais, state your name for the record, and tell us what you like, I hope, or don't like about the proposed regulations.
Thank you, Mr. Chair. Matt Petler, School Facility Consultants. I appreciate the opportunity to address you. I wanted to comment on the comment that you made, Mr. Harvey, regarding the amount of money available under C. The West Contra Costa Unified School District would appreciate that their project is contemplated in that number. As Mr. Zian pointed out, their project is different from the other 21 who've just been surveyed. The West Contra Costa project has gone through that process and has actually been approved by the board as meeting the criteria of the current regulations and are just working their way through DSA to get in line for an actual unfunded approval and apportionment. So I just wanted to make that comment to the subcommittee.
Just get it in, keep working. This will take a while to be approved. You know, it'll be 4 months, so just work.
Believe me that we are. Thank you.
All right, thank you.
Mr. Petler, are you in DSA?
We are in DSA. And in fact, appreciate DSA has reached out to the district to make sure that they know that project and are knowledgeable that project is their seismic
So
project.
isn't it pretty likely that that project would be ahead of anybody else coming forward?
I would hope so. Again, though, if the regulations get approved and other projects already have DSA approval that meet this criteria, it's possible that they could be ahead.
Because we rarely in regulation call out, an accepted district. We try and create a date or a line or something that is applicable across lines. And I just wonder, though, the real possibility that 170 million would come ahead of Contra Costa, and whether that's really really a high risk.
Sure, and I appreciate that comment, and I think frankly we just don't know. What we do know is that this project is in DSA, and that the district and DSA are working as hard as possible to get the project out of DSA.
Dave, on point. Is this on this testimony?
Yes, it was actually a comment you made, just a point of clarification, Mr. Chair. We will endeavor to file these on an emergency basis, so it may not be 4 months if we're successful.
How are we going to justify the emergency?
When we made changes from the 1.70 to 1.68 in 2009, they were filed on an emergency basis. These are health and safety projects, and we believe they should be filed on an emergency basis in this latest iteration.
I'm for expediting. That may be a policy call that's made at another level, but
whether or not OIL approves the emergency basis, that's
I'm
the
just
question.
nervous. We had something else on an emergency basis. They kicked it back, and we're starting at ground zero. Anyway, we'll talk about it, but if we have a track record for these kinds of things being expedited, that's good news. I stand corrected. Once again, this is my day of correction. My goodness. Mr. Smoot.
And again, given that as well, if it may be expedited, that I think pushes the West Contra Costa's issue a little bit more. So we appreciate your consideration of that.
Thank you. Lyle, for the record, your name.
Good morning. Lyle Smoot, Los Angeles Unified School District, and I'm going to get pretty close because I've never had asthma, but for some reason this year I decided to get it, so I probably sound like a frog. I do to myself anyway. We have a number of things I'd like to talk about on these proposed regulations, and so I'll try to go through them quickly. Let's start with, on page 2, the definition of a Category 2 building. There's a whole bunch of stuff delineated here, and it seems to us that if there's some place that these came from, that you could just point to that, because if, for instance, whoever did these originally decided to add something to it, or if the board wanted to add something to it, you'd have to go back through a regulation. If you just pointed to something where these are already delineated, you wouldn't have to go through a regulation change if something else was added to the list. And I just think that would be important. Of course, first of all, I don't know where these came from, so I don't have any way to go look at some list and see if this is a complete list of all the Category 2 buildings. So it'd just make it simpler if you just point to something and say these are where those came from. And
let me ask DSA, or is there a chance there would be an addition to the Category 2? I thought this would be it. I mean, do we add building types commonly? I'm kind of like the idea that people can read it and see it and feel it and touch it rather than having to go to another document. What do they mean? But it's a good point, Mr. Smoot. Masha, to answer the question about whether the laundry list of buildings would change or things would be added to Category 2.
No, as I understand, the Category 2 is referenced back to the authorizing statute that links it back to the report that DSA prepared in response to Assembly Bill 300. And those definitions came from a national engineering standard from ASCE, and also there were a couple of building types that were subset of those nationally recognized building types that were added in the AB 300 report. So that's, if you take that text and you compare it to the AB 300 report, that's your point of reference.
Well, that might be harder to track back.
Well, AB 300 report is posted on our website. I believe it may be also posted on OPSC website, and I think it's page, I can show you right here.
you don't need to show me, just tell me.
So,
where
Marcia, the Category 2
11.
list of buildings is from the AB 300 report?
Yes, in accordance with the regulations section of, in your page 1 of your item on the authority, If you see the school facilities that are identified as Category 2 buildings as defined in the report submitted pursuant to Section 17317, that Education Code section references to Assembly Bill 300 report. And that's page 11 of the report.
Just to further clarify, the term Category 2 only shows up in that report.
That's
so
the only
this, by clarifying the building types here in these regulations, it's a usability factor.
I like it.
The reader, the user knows what we're talking about right here without hunting down a report somewhere.
Chip, is there a reason that one of them got crossed off from the existing regulation? So did we, yeah, what happened?
Well, it was the way it was, I think you're speaking to the C3A.
Yes.
And it was typified incorrectly, is my understanding, so we struck it out and then we put it back in. You'll notice it's struck out, but then it's back in, but look at the wording, it's a little bit different.
Oh, up at the top.
And it was actually for ordering purposes, just to put all the Cs together.
Gotcha.
So it was simply just to group and, again, for usability purposes.
Well, and just in response, Mr. Smoot, I, for one, kind of like that the districts can know exactly what we're talking about, Category 2 and the board. And it sounds like it won't change because it comes from a report that's been done, correct?
Correct.
So
It's static.
there won't be more changes to it.
Right.
No, actually, given that explanation, I see no problem with this. I mean, it doesn't sound like there's going to be any additions to it because of the process that was taken to get to this point, so that's fine.
Number 2,
can we
then.
move to the next issue?
Sure.
Through this report, a couple places, and I realize some of it is existing statute language, but the reference is to most vulnerable Category 2 buildings. That's not what the law says. The law says the most vulnerable buildings that are designated as a Category 2. I realize that's a fine distinction, but it is a pretty substantial potential distinction someplace down the line. And it'd be nice to have the words in there correctly.
If they're in the statute that way, perhaps we can reflect it the same way.
Well, that
here.
potentially solves the other problem. I think you either strike most vulnerable and leave just Category 2 buildings, or you say most vulnerable as, use that language.
Use that language. I'm more comfortable using the language in the statute.
Me too.
Yep.
We'll use the language in the statute. You're
Thank
1
you,
for
sir.
2, Smoot.
That's the
What
other
else?
problem.
1 for 2.
Let's see if we can try for 2 out of 3.
Your one, though, was good to clarify.
That is
I'm sorry?
Your one was good to clarify, though, so we all know where.
We're applauding that clarification.
Thank you. The next issue is under C, and Mr. Harvey, you're not going to like this. Pointing to the $199.5 million means that if there was additional funding added someplace down the line, you'd have to come back with a regulation change to be able to act upon that. I was just wondering if it wouldn't be better to just leave the dollar value out and just say, funding that's made available from this or subsequent
We can
action.
do that, or we can reference back to 1D, so we know that the 199 was attached to 1D, and if there's a proposition XZ in the future that sets aside money for seismic, that would be separate from.
That's what I was thinking. If you just reference the amount in 1D section so-and-so or other funding that may become available, to resolve that issue, and you wouldn't have to go back to the regulation change.
Staff, any issue with that?
We typically come back and make regulatory changes when a new bill is implemented, so that would be no problem. But we would recommend that we keep the 109.5 or reference the current.
And say per the
statutory.
Proposition 1D or whatever the qualifier is.
Yeah, whatever year, one in
As 2019 or whenever it was.
2006.
The next issue is a little more difficult. I guess the words in C4, second line there, result in a high potential for catastrophic collapse. I don't know what a high potential is versus a medium potential. I just think the term high creates a subjective issue that may or may not have relevance someplace down the line. And the second part of that is catastrophic collapse versus collapse. Again, these are not the terms that are in the law. The law uses the term unacceptable risk of injury. I don't know that we have a necessary problem with changing that to say.
What law are you citing when you say
I'm sorry?
unacceptable? Which language are you drawing from when you said the law says? What law?
That's the education code in whatever the section that's referred to, 17 blah, blah, blah.
1803A.
Or maybe it may even been the language
You
in
mean
the
the building code 1803A here, or are you talking about the education code?
He said education code.
Yeah, it's the education code.
Well, you're getting back to something we opened with. Can we have a little discussion by staff on that term and why it was selected, what it may mean, and if the California Geological Survey wishes to chime in, I'd appreciate hearing from them. But I think it was trying to capture the kind of discussion that Ms. Buchanan referenced, was that there had to be some, and she used the term imminent. We decided that didn't really work at some earlier hearing. So it was attempting to say it really should be those instances where there is a catastrophic, imminent, high risk, whatever the terms are. But staff, if you could help us understand why potential for catastrophic collapse in a seismic event was selected, it might help us all.
I wasn't involved in the original development of the policy, but Dave, were you?
I think it came from us.
You were not.
Actually.
It
probably came from the board.
From the board,
Okay.
yeah. And it was read into the record.
No, I understand that the term high wasn't in the record. It just says potential for catastrophic collapse. I'm just pointing out here that both of those terms, the term high and the term catastrophic, create different pictures. I mean, catastrophic versus regular collapse, I'm not sure what that might mean, but I mean, one person dies versus 100. I realize that's a bit of an excessive statement, but at the same time, you know, is somebody going to look at this sometime later and say, well, you don't have a high potential and you don't have a catastrophic collapse because your potential is only 50% chance and only a couple of people are going to get hurt. You know what I mean? So I don't think we need to go back. Of course, we like the words in the law, but nevertheless, and I understand, Ms. Buchanan, your reason, or I think I do, your logic behind using the word potential for collapse. And I think if you just take out the word high and catastrophic, we'd have a lot less concern with it.
All I'm going to say is if we read it into the record at the board, we need to reflect that. If high is in, we keep it in. If it wasn't in, we take it out. Whatever was read into the record at the board is where we should be. And if Mr. Smoot wishes to come and ask the board to alter its motion, that would be, I think, the course of action. So if you could simply assure us that whatever was read into the record is reflected here.
I think
In the record of the last board meeting.
Right.
The last board meeting.
And I'm not sure it was high potential, but I think what happened was this was a combination of my wording and Ms. Moore's wording, where I said, look, if an engineer tells me as a school board member that this building isn't safe and you should not have students or teachers occupying it, then that to me is
a high potential.
It's not a high potential. That to me is the red flag to say, you know, we've got a problem. You know, you can't have kids occupying it. It's not safe. And I think it was Ms. Moore who added the catastrophic collapse. So I personally am not wed to any particular words. I don't know if I would just go potential because I don't want to, you know,
Right.
Yeah,
I don't want to
understand.
open the gates more.
I believe what the board approved is it says must have an accompanying structural engineer's report identifying the building deficiencies and reasoning for conducting the building has a potential for catastrophic collapse, and we added in a seismic event, including but not limited to.
Right.
That was the language recommended by that was a motion at the last board meeting to incorporate that language.
Right.
So that language didn't have high in it. And I guess what we're pointing out is we're implementing the language, we're implementing it now, and to keep with what the board approved, we'd have to keep the potential in.
For catastrophic collapse.
And then if
In a
you,
seismic event.
we could
Seismic event.
discuss it at the board meeting.
There.
So I think
about
we should, based on that, we should take out the word high, but leave potential for catastrophic
Collapse in a seismic event.
But Mr. Smoot is correct, because the Ed Code says, determined by the department to pose an unacceptable risk to injury to its occupants in the event of a seismic event. That's what the law says.
Well, maybe there's a way we can put that modifier in there. Catastrophic collapse that poses or whatever, and add the Ed Code language in there.
And I think our concerns are more, not so much with the fact that it doesn't reflect exactly what the law says, as it is that the terms create a subjective decision-making potential. And, you know, I think everybody understands what you've said. You got an engineer's report, says the building's going to collapse, bang, there you are. But then, you know, sometime 5 years, 2 years, whatever from now, somebody reads that and says, wait a minute, this isn't a high, you know, so I appreciate your.
Well, Ms. Buchanan's made a suggestion where we would keep the phrase potential for catastrophic collapse and then add the language from the Ed Code. Does staff have any?
Or refer to it or something, yeah.
Does staff have any visceral, off-the-cuff comment about that addition at this point?
No, I think that's something we can work in.
Well, why don't we add it then? And
Okay.
again, we will discuss it at the board, and we'll have time to cogitate and think about it.
That'd be great, thank you. The next one is,
I thought you only had 3.
no, I said the third one.
Okay.
I have actually 5 more. So the next one is related to the, in C4, the conversation about an engineering geologist in accordance with California Building Code Section 1803A and with the concurrence of the California Geological Survey. I don't know that there's a problem with an engineering geologist or with using 1803A, but the concurrence of the California Geological Survey adds another bureaucratic layer to this and a potential increase in time and an increase in cost. So since there wasn't any, I don't recall, I'm not going to say there wasn't any, I don't recall a conversation about adding this layer. I would like to know if it's really a necessary layer, if it's just something.
Let's hear from DSA. I mean, I'm comfortable with it. I see Ms. Buchanan's comfortable with it. It's a validation of what the district's representative is saying. I think we want to make darn certain it's accurate and complete and thorough. So I see, Chip, you look like you may be wanting to respond. I'd appreciate your comments.
Yeah, this provision is here to address the fact that we at DSA and structural engineers aren't credentialed in the geologic hazards arena. So this concurrence by the California Geologic Survey, we feel is needed. They have the expertise to.
No, I understand that. I'm just saying this is a substantial potential cost to the district, just another cost. And by the way, I don't know, your conversation previously about this only being required if there's the presence of faulting liquefaction or landslide hazards. I don't know what other situations there would be where there would be a collapse.
Isn't there, Lyle, don't all projects have to have a geohazard report? Aren't they required to? I mean, that's only when you're acquiring land?
No.
I remember
They
in
have
my
to have a
days in the
geological
district, every
survey.
project had to have a geohazard report.
You were on a bunch of faults and landslides.
But I don't think
No,
it's,
as
I
a
don't think
requirement.
it's necessarily, I don't know. I'm not going to try to answer that because I really don't know the full answer. I don't think it has to be concurred with by the California Geological Survey. Now, I may be wrong in that, and if it's
Mr.
if it is-
Yeager,
if
do
it
you
is
know?
a current situation, then fine.
Concurrence doesn't imply a lengthy, costly review file. I think this is a.
I'm not worried about the review necessarily. I'm worried about the report itself and what
But
depth
if
of
you're
the
claiming the reason the building's unsafe is because there might be liquefaction, and what we're saying is we're opening up, we're making the requirements broader because we want, the buildings that aren't safe to be occupied to qualify if it's due to a seismic condition. But for the answer to the people that say, well, how come, how do I know you're just not going to get any engineer to write a report for you? What we're saying is the standard you have to meet is concurrence the state, DSA, they have to concur with it. So what DSA is telling us is that we don't have the expertise to concur with these conditions. So what we'd like to do is be sure the Geological Survey concurs with it. So I think that's consistent, unless I'm missing something.
I just was wanting a conversation about this because it wasn't in the original conversation that the board adopted. So I wanted to make sure that you, obviously not us, but you concur that it's a necessary action because it is expensive. That's all.
But aren't you going to do that anyway?
I don't think so.
Well,
not this one.
When,
but like I say, let's check that out. If I'm wrong, I'll be glad to come forth and tell you.
I can tell you, because I was on the school board, not when we applied, but when we did all the work on the gym at Santa Ramon High, and we had to do all that geological work in order to determine that we had a liquefaction situation. So, I mean, it was part of the work we had to do to submit.
We can go past this one, and then I'll talk to my district.
I'd like to hear from
Let's
them.
hear from, we may.
Okay, Jennifer Thornburg with California Geological Survey again. I think to clarify the point, if you're purchasing property, there is a requirement for a geologic hazard report. That report is not reviewed by the State Geological Survey. If you are doing new construction, however, this process that's being proposed is very similar to what happens under new construction projects.
Good. Thank you for that clarity. Lyle, next.
Okay. You've already addressed this to some extent, but in listening to Masha explain the process that DSA goes through to establish the guidelines, I wonder if you couldn't just ask them to have an open hearing such as this, because, a lot of the people that would otherwise potentially be left out of that process would probably like to have an opportunity to hear what the guidelines are before they're adopted.
I think DSA is agreeing to hold such a forum. Next.
Cool. The next thing is under D has the same issue with the catastrophic, with the vulnerable Category 2 buildings, most vulnerable Category 2 buildings. I assume that'll get addressed along with the other one.
That'll be addressed, thank you.
In E, if an application for the seismic mitigation of the most vulnerable, again, Category 2 buildings cannot be fully apportioned or approved for placement on the unfunded list, that goes to that conversation about what are you going to have an unfunded list that it goes past the dollar value of the whatever amount of money you have available, and we'd like to see an unfunded list. So that wouldn't be appropriate for an unfunded list. It would be appropriate for apportionment only.
I think we've agreed that we'll leave it like this, and we'll have the unfunded discussion at the board, because that's a change in policy.
Yeah, I just kind of reiterating that we're in support of that conversation.
Very good.
The term here, lack of AB 55 loans, I don't know that that's a relevant place for that, and I don't know why that's in there, because you could have an unfunded list for reasons other than not having AB 55 loans. That's maybe what generated all this, but you have it now not because of lack of AB 55 loans, but because you haven't sold a bond.
Juan, if you want to indicate why that's there.
That's the current definition that we have in regulations, because that's the unfunded list that we're working with now. And that's why we referenced that particular regulation section. We don't have the other unfunded list. The board hasn't created that yet, but this is what we do have now. That's why we referenced that unfunded list.
Okay. It's still a term that makes no sense at this point.
Can I just ask a follow-up, not a follow-up, but Mr. Harvey, on that particular line, we're going to put for full board discussion, not as a recommendation of the subcommittee. Is that what you were indicating?
No, what I was saying is we will leave it as drafted, and we will have a full discussion. Staff will indicate that there was the viewpoint expressed saying this and the viewpoint expressed saying that, and that will call it out. But I think it should stay in.
Well, I'm wondering if we can have what we agree upon to go forward as the recommendation of the subcommittee, and what we don't agree upon should be considered by the full board. as a discussion. That's typically how we take some subcommittee work forward. If it's all of us pretty much, if we agree to how it reads, then that's what moves forward. And those items that we don't necessarily agree on, we can have the full board discuss.
I was trying to do it by consensus, but if we want to vote, we can do that as a subcommittee.
Could we just ask staff that when they write up this item that we indicate that we need further discussion by
Yeah,
this?
that's how I
on this and
envisioned
the
it.
full board?
Okay.
That's how I
Just so that it's shown that it's for full board discussion.
And my last issue is with regard to the part where it says the applicant may either reduce their request to the remaining funds or refuse funding entirely. I'd like to see a conversation about partial apportionment and leaving the project open to subsequent funding if any funding becomes available. You know, you could have a, whatever, $2 million project. You only got $1 million left, so the choice is to take $1 million and go ahead on a project you have no choice but to go ahead with, or take nothing. Well, clearly, you know, a district is going to have a lot of pressure to take the $1 million and leave the other $1 million on the table, but the next funding that comes in, maybe savings, I don't know, some money comes in, and instead of that project being made whole, the next project gets funded, and that just seems to be I hate the term unfair, but I think it's unfair.
Well, again, I think we will get to that issue if you raise it at the board, because we're calling this section out. But I think staff laid out an eloquent justification for how this is used in 3 or 4 other programs, and that it seemed appropriate here, but it will obviously now be discussed at the full board.
Thank you.
I just have a follow-up question. So on our other programs, when we get to the end of the list, we say you must take partial, none at all, or none at all? Is that how we treat the list, the end of the list?
Several different systems for different programs, and some we allow them to skip, like the current priorities and funding. There's not enough funding cash for a next project on the list. We can pass up a project and offer it to the next one, so it varies.
But those projects stay on the unfunded list and anticipate another bond measure or future funding to come in and fund them, rather than just giving up, you know, what maybe.
So, Mr. Smoot, are you asking this, that if you're the last one on the list and your project's $2 million and we only have $1 million left, that you get funded for the $1 million, and if $1 million becomes available, you are made whole, which seems reasonable? And do we do that in our programs at all?
I think the question is that if you only have $1 million left in bonding authority, whether you keep the other $1 million available for future funding. That's the way I understand it.
And that's what, and see, I was going to say that there's a difference between if you have more bonding authority and you're going to sell, so you're taking partial apportionment this month, but next month you're going to have more money, and when all the bond funds have run out. Now, the only exception that would be is if some of the projects come in less than they were apportioned, and there's more money that returns to the program. But
well, historically,
you've
gone past bonding authority with your unfunded approvals on new construction modernization. You've paid very little attention to how much bonding authority is available for an unfunded list. You've gone ahead, and then when money comes available from the next bond measure, you funded an unfunded list.
Right, you're assuming that there's seismic set aside. I mean, that's the problem with these special. I don't know what the answer is on this.
I'm just saying,
it merits more discussion.
You take the money, you're running a risk. Yes, understood, but that risk shouldn't be made worse because you ran out of money today, but you got money tomorrow.
Yeah, I understand that, and
okay.
And if you didn't have a seismic program for 10 years, at what point in time, so I don't know what the answer is.
Well, I don't either.
And certainly if money came back into the program because some of the projects ran under, then I would think you would be the first to be made whole there
That's
as well.
more or less. That's mostly what I think would happen, is that you'll get money back from other projects and maybe be able to make that project whole. Thank you very much.
Thank you.
I appreciate your listening to me today.
Our pleasure.
I think so. Now, Mr. Chairman, members, Tom Duffy for Cash, and I'll be brief. And I want to talk, I know you're going to have further discussion with the board, but I just wanted to try to respond, Ms. Buchanan, to something that you said and also that you had said, Ms. Moore. Mr. Smoot is correct. In the history of this program, beginning in 1982, we would run out of money and we'd have an unfunded list, and that helped us convey the message to the legislature and the governor that we needed another bond. And we have been consistent, and we're consistent with that through the 90s, and then we've been fortunate with the bond measures we had in 98 and 2002 and 4 and 6. With regard to program change and whether or not there's a seismic program that looks like this, Ms. Buchanan, in 1998, when we established Senate Bill 50, there was a significant change, as you know, in how the program must operate and the funding methodology. We gave districts the option of withdrawing and reapplying for the new program, and there were some deadlines. I think that very same thing could happen here. So what I would argue for is that California has finally put together a seismic program. And I want to thank the three of you for the way that you have really taken this issue and looked at it in great detail, because I think this is a very workable program now because of the effort that you've made. And I would want this program to then continue to be the model, and if it needs changing because of what we learn in the future, then we can certainly do that. But back after AB 300 was written and there was the controversy of it, we went to Ellen Corbett, who was still in the Assembly at the time, and asked her to carry a bill for us that was the seismic bill. And we got it through the Assembly, got it to John Vasconcellos, who chaired Senate Ed, and the senator said basically, well, we don't have a funding source for this program, so we shouldn't really move forward, and he held the bill. So we had to wait until 2006. Now we have a program that is defined, and I think we could argue, especially as we see it unfold, that we could argue that this would be the basis for what we do in the next bond. But my last point, Mr. Harvey, is that if we do what we've done in the past and do as Ms. Moore suggested, then we are taking the AB 300 list that you have a high regard for and identifying that whether it's buildings on that list or not, we see that there is need in California. And we're encouraging districts to come forward, and it's not an easy thing to do at the school district level to tell a board, and you know this, having been a board member, to tell a board, we can't use this building because it may collapse, and what that does to the community and what that does to the children that are going to that school, or the students. So my argument, Mr. Harvey, would be that with the kind of program that you have now put together, we would want to encourage districts to make application based upon what's here and establish that pipeline so that we can argue for the program in the future. California is a high-risk state with seismic events, and I think this is a very positive step. Thank you for your time.
Thank you, Ron. The other thing I want to say, we've said it more than once, while we have the set-aside program, and we all, I think, submit it's going to be an improved program, we still have in place the facility hardship process, and folk that can't necessarily qualify because the dollars may ultimately go in the seismic program, they do have another avenue to seek funding. And seismic is one of those events. In fact, we funded one based on faulting under the facility hardship. So I just want to make sure folk who may be listening understand that we do have more than one avenue, and we will continue to.
But Cash wants to sincerely thank you for the work that you've done.
Well, thank you for participating. Without participation, I don't think as good a decision is ever made. So hearing the voices is important.
Well,
any final comment?
Having a program that started with a bond in 2006, and finally we're able to, I think, see some movement with it. Thank you.
Good. Staff, any closing remarks? Do you have any concerns on the direction and requests we've made to change and amend and alter this before the board sees it?
No, we'll just work ambitiously to get this together and post it to our board book next week. So.
Well, I think, again, I want to thank all of you, both at DSA and at OPSC and the California Geological Survey and others who come to take their time to make sure we're better informed, and the work you do to create these documents are certainly appreciated. Thank you all. We'll see you at the next board meeting. This committee meeting is adjourned.
All right, thank you.